Good morning. We are here in case number 316-2024, ET-225, the estate of Harmony Montgomery. I'm Judge Kissinger. We're here in the Ninth Circuit Probate Division in Nashville. And we're here on a petition for administration of an estate of a person presumed dead pursuant to RSA 55318 and 55319. And we are here on that petition submitted by the mother of Harmony Montgomery, Crystal Sorey. We also have via WebEx from the New Hampshire Department of Corrections in Concord to allow for attendance of the father, Adam Montgomery. This is an intestate estate, so service was made on both mother and father, and by publication. So I'm going to start by asking just the parties in the courtroom to identify themselves to the record, starting right here.
Good morning, Your Honor. Sheila Caulfield, I'm counsel for Crystal Sorey, who's with me today.
State your name again.
Hi, I'm Crystal Sorey.
All right, and on the WebEx, can you hear me?
Yes, ma'am.
And is Mr. Montgomery attending?
No, ma'am. My name is Corporal Winkowski on behalf of New Hampshire State Prison for Men. He did refuse. There will be a written memo that goes to the major and then to the commissioner.
Okay. And sir, can you spell your last name for me?
Wienckkoski.
Wienckkoski? Okay.
Yes, Your Honor.
All right, thank you, sir. You may be
Thank you.
excused if you want to.
Thank
All right, thank you, sir. All right, so we're going to proceed then with a petition. We now know Mr. Montgomery won't be attending. So, Attorney Caulfield, it's your burden. It's your burden to demonstrate that by clear and convincing evidence that Harmony Montgomery is presumed to have been killed as a result of some catastrophic event, and her body has not or could not be recovered.
Thank you, Your
So do
Honor.
you want to proceed by offers of proof?
Certainly.
All right, so who are you going to be making an offer on behalf of?
I'm going to be making an offer on behalf of Ms. Sorey.
All right, Ms. Sorey, I'm going to need to put you under oath. So we're going to proceed on offers of proof. And what this is your attorney will be making an offer on your behalf in order to satisfy the elements of the statute. If she says anything that's incorrect, you have a duty to correct record. I may have a few questions for you, and we'll proceed from there. Okay? So please raise your right hand. Do you swear any testimony you give this proceedings the truth and the things and penalties of perjury?
I do.
Okay. Go ahead, Attorney Caulfield.
Thank you, Your Honor. As a housekeeping measure, I do have a copy of the return of service if the court would like to see a copy, and I have the tear sheets from the paper.
Okay, I'll take the copies and we can do the tear sheets so we can stamp them in. Okay, thank you, Attorney Caulfield, go ahead.
As for the evidence that Harmony is in fact deceased, Your Honor, I would request that the court take judicial notice of the fact that Harmony's father, Adam Montgomery, was recently convicted of murdering Harmony. And more importantly, within that process, Adam confessed to a lesser charge of purposely and unlawfully removing, concealing, and destroying her corpse. In addition to being convicted of her murder, Adam was also convicted on that lesser charge of mishandling her body. Further, Kayla Montgomery, who was a key witness in that trial, also testified to handling Harmony's dead body. These acknowledgments by the two people who were last known to have physical custody and care of her should serve as sufficient evidence for the court to accept the presumption that she is in fact deceased. Further, no one has seen this child since December of 2019, when it is believed that Adam murdered her. That's over 3 years ago that she has not been seen by anyone. With respect to appointing Crystal the administrator, she is the child's mother and next of kin. She has priority under RSA 553-2 as her next of kin to administer her estate. And further, under RSA 561-1, she is a beneficiary of that estate. So she is she has a substantial interest in properly managing the estate and protecting it, and is in the best position to do so. Therefore, we request that her petition be granted and that she be appointed accordingly. No one else has filed a petition, so she is the only petition that is currently pending before the court.
All right. I am going to require you to give me an authenticated copy of the jury verdict from the Superior Court. And there's a lot of hearsay involved here.
Certainly.
And so we're going to need that I'm going to need that within, say, 5 days. And I'll make my final order after that. I do have some questions concerning moving forward. Again, the issue is whether you satisfy the burden under by clear and convincing evidence. The other piece of this petition for state administration is whether Crystal Sori is the appropriate administrator. And that includes submission of a bond. That includes moving forward under Administrative Order 7 and Rule 101 of the probate rules. And we'll get into that in a moment. So with respect to the bond, you filed for an expedited hearing because the intent was to file wrongful death actions. Is that right?
That's my understanding, yes. I'm not handling that case, however, that is my understanding from the attorneys that are.
Okay, and that's the attorney, and what's the name of the attorney?
Attorney Russ Riley.
And are those in Massachusetts, New Hampshire? Because I couldn't tell from your...
I believe New Hampshire.
In New Hampshire?
Yes.
And it's a wrongful death action, right?
Yes.
Or it's anticipated, I mean, that's...
It will be, yes.
All right. Okay. So, a couple things, Ms. Sori. If I appoint you as administrator, you're going to have duties to the court, and I need to make sure that you're the appropriate person who can fulfill those duties.
Yes.
These include providing a bond. So, has there been any offer, is there any indication of the amount that you expect to recover or hope to recover in your action, or you haven't gotten that far?
I don't believe we've gotten that far.
Oh.
I don't, there's not a set amount yet, I don't believe. Russ hasn't spoken of one.
Okay, all right, so I'm considering then setting, this is not, I've worked on other cases involving wrongful death actions of this nature. The numbers can be all over the place. However, at least to start, I'm going to ask for a $10,000 corporate surety bond. Are you able to post that? You have to go to an insurance company, get the corporate surety bond?
Okay, I could do that.
All right, so before the administration will be effective, it's a $10,000 corporate surety bond.
Okay.
The other issue is because this estate is essentially being opened to pursue a wrongful death action, I'm assuming Harmony had no assets.
No.
That because it's to pursue a wrongful death action, it would be subject to the requirements of Rule 101 of the probate court rules and rules Administrative Order 7. So I'm going to require status reports as to the status of the wrongful death action. The first one will be due in 6 months. Okay? And I'll
Yes.
put the dates that will be due in the final order.
Okay.
One last issue with respect to a wrongful death action. If it goes to trial and there's a verdict and a judgment, or if there's a settlement, you have duties to the estate, but also to the court. And under Circuit Court Rule 88, I review in every case, in every estate case, all attorney's fees.
Okay.
So there may be a settlement, for example, it's an ongoing issue in many cases. There may be a settlement in either Massachusetts or even if it's in Massachusetts or New Hampshire. The gross amount, meaning the total amount before payment of attorney's fees, needs to be deposited in the estate account. Then you report that to the court, and your attorneys submit their fee, their billing statements.
Okay.
And you are not to release those billings, what they're going to take as a fee until it's approved by the probate court.
Okay.
Okay?
Yes.
And so what that means is the entire amount will come into Harmony's estate account, the estate of Harmony Montgomery account.
Yeah.
Then the attorneys will file a motion for fees, and then the court will approve them or not.
Okay.
And so that's subject to not only our statutes, but also the common law. And even if there's a contingency fee and the Superior Court signs off on the contingency fee, under not only our statutes, 55614, but also Cody versus Martell, 103 NH 110, the court needs to review those fees. And the
Okay.
expenses charged by attorneys. And that's just an additional duty if I were to appoint you as Harmony's administrator.
Okay.
So Attorney Caulfield, do you expect to be assisting with the estate administration through the final closure, or what is?
I plan to be counsel through the closure of the estate, yes.
Okay, all right. All right, anything further then?
Nothing further.
I'm going to go ahead and condition on receipt of the authenticated copy of the jury verdict. I'll proceed with issuing orders as soon as I possibly can, and get some conditions on the bond, and also a submission of the bond, and also on submission of the authenticated packet. Okay?
Thank you.
All right, thank you. I wish you all the best, ma'am. Thank you. Pleased to see you.
Thank you.
The drive.